What's up, everybody? It's Stephen A. Williams, president and founder of the creditrepairshop.com. And in today's video, it's going to be a quick one. Just wanted to make you aware of something. This came into our office, and we're seeing this happen a lot where people are thinking that they're getting sued by a law firm or debt collection law firm. And if you read closely the information that they enclose, it is not really true. So I want to show you this. I got it covered up because we don't want to reveal anything about a customer. But I want you to read something. They sent this as a summons. This was part of a package with a summons that they sent to this individual. And it is a law firm that is representing the plaintiff. And I want you to read something right here because we caught this. And it says right here, at this time, no attorney with this law firm has personally reviewed the particular circumstances of your account. And before I move forward, I just want to ask you, please like this video. And also, if you haven't subscribed yet, please subscribe because I'm going to start sending videos that are only going to be able to be viewed by subscribers because I have some information that I'm going to get out and I want to make sure it doesn't get out to the wrong individuals. I want to try to at least clamp down as much as possible on that. So you see this right here. It says at no time, no attorney with the law firm has personally reviewed the particular circumstances of your account. But they sent this in a court summons. But when the customer looked up on their website for court cases, there was not a court case placed or scheduled. And I'm gonna tell you why. And the debt collection companies are doing this tactic, and original creditors who hire debt collectors or law firms to go after debt. They're using this tactic where they will submit all the documentation to the court, but they don't pay the fee. They allow them to load up everything digitally, and they allow them to get a case number. Some of them don't. Some of them don't allow you to get a case number unless you pay. And then in some jurisdictions, they do allow you to get a case number, but you don't pay the fee, so it's not executed. And so there's no court date. But they're using this as a scare tactic. And one of the problems that I see with this, there's a huge problem that I see with this is that you can send this. This is technically should have been the 30-day letter, but they sent this packaged up with a court complaint, which was not filed 100%. And an attorney put it together, but it says at this time, and they're stating it right here, no attorney with the law firm has personally reviewed the particular circumstances of your account. And then they go into this information here, right to cure, all of that stuff. Right to cure means that you can pay a certain amount and they will bring the account back with I guess this is with the original creditor. And they will let them uh, pay that amount and then they can start back up with their account that they have. But something that I want you to look here too before we end the video, it says that unless you notify the firm within 30 days after receiving this notice that you dispute the validity of the debt or any portion, therefore, this firm will assume that the debt is valid. So if you don't respond, and I talk about this all the time, the way that the laws are made, if you don't respond, you are actually saying that you owe the debt, that there's no problem with the debt, no problem with any amount of it, anything. So, what you should do, what you should always do, regardless if you're dealing with the original creditor or a third party debt collector, but you should always do it when you're dealing with a debt collector, is that you should make them do a validation of the entire debt. And the reason why, if you look here in this paragraph, it says that they will not they will if you exercise your rights, if your rights are timely exercised under this paragraph, the firm will cease our collection efforts until we have sent you verification of the debt or the name and address of the original creditor, because they might choose not to deal with it. And if you have the right validation letter, the right cease and desist letter, which I'm giving to you. And all you have to do is fill in the information and send it to them. You could potentially get the debt either sent back to the original creditor because the debt collector says, I'm not touching this because the letter that they sent, if you don't provide all of this information, we're not going to go through it. And then once an attorney reviews it, see, they do this for a reason. If an attorney reviewed it and then they sent out this information, they have to assume that everything is correct. But because an attorney didn't review it, they're giving you the opportunity to review it. And then if you do not respond, then they will proceed and move forward. But you still have options even if it does go past 30 days. You can do the debt validation because usually attorneys won't review it until they go to court. And looking at this one here and from the other documents that this customer sent over to us, they tried to play a trick and say that they did file a court case, but they really didn't. And they slipped in this letter, I guess, to use it as a way of having all of their ducks in a row, saying that we did send this letter to the client to allow them to be able to review and dispute the debt. I just wanted you to be able to take a look at this because this was some information that we had gotten before, and I had meant to make a video about it. And you need to be aware and watch out for this because this is just another dirty trick that debt collectors can try to use. All right, this is Stephen A. Williams, president and founder of the creditrepairshop.com. Make sure that you subscribe to the channel, ask your questions, and also like the video so we can help more people, and make sure that you subscribe to the channel. Thank you.